Thank you for watching. My name is Advocate Mohammed Abduroaf, and today we'll deal with a question, an interesting question. The question goes as follows. What is the best way to get married? In community of property or out of community of property? Now, this will obviously apply to people who intend getting married in South Africa at least. We'll have to start from the bottom up. The first marital regime you find yourself in or may want to consider would be that of getting married in community of property. And there are two others that we'll deal with shortly. In community of property basically means that there is one estate as opposed to being two estates. So before you got married, the husband will have his own estate. He'll owe people money. People will owe him money. He will have money in his bank account that belongs to him. And the intended wife will be exactly the same. She will have money in her bank account. She'll owe people money. She might owe the university money. People might owe her money. And that's the situation. Whatever belongs to him belongs to him. Whatever belongs to her belongs to her. So there are two separate estates. Once they get married, there is no longer two separate estates. There is only one estate. So, for argument's sake, let's say I owe the husband money. He's married now. Before he got married, I owed him money. After he got married, I will now own the joint estate, the money. Meaning that the joint estate will be the creditor to me. And the same way, if the husband owed me money before he got married, while he's married to his wife, I now tell him or mention to him or demand from him, please pay me the 50 rand you borrowed from me 2 years ago before he got married. And he doesn't have that money in his bank account, but his wife has that money in his bank account. Because they are married in community property, there is no longer two separate estates. I can take his wife, I can take the joint estate to court, and ultimately the wife will be paying that 50 rand back to me with money that belonged to her before she got married to her husband. So basically, in community property, before you got married, there's two pots. What happens now is a bigger pot gets created and all the debts and all the assets get thrown into one pot, and that is now the new joint estate. If the husband gets into trouble and he owes people money, you sue the joint estate, and ultimately the wife might have to pay for that. If the husband obtains money, people give him, let's say, 1,000 rand, his wife would have a claim to that money because it belongs to her. And at divorce, if they were married in community property, at divorce, this pot that they have now, this one pot, will have to be divided, cut into two basically, and both parties will have to leave with their respective shares. This will also consider whatever debt they have incurred. So for argument's sake, let's say during the marriage, the wife bought a lot of nice clothes on account, and the husband never done that. He was the one that saved money. But because she bought all these clothes on account on credit, that money for that clothing will have to be paid from the money that he earned, because she never earned any money. She was the one that spent all the money. But she's in debt to the shops. Therefore, obviously, before the joint estate can properly be divided, that specific money that's owing to the shops must be paid for by the joint estate. I hope you understand where I'm going to. So at the end of the whole scenario, if you're married to someone in community of property, whatever assets you've accumulated, it belongs to the joint estate. It belongs to both of you. And whatever debt either of you have incurred during the marriage, it belongs to both of you. And at the end of the marriage, the books has to balance, and each one of you must leave on the same footing, the same amount of money, positive or negative, in your bank account. So that's in community property. After I've explained that, out of community property will make more sense, because out of community of property basically means there are two estates. So when you got married to your spouse, just before you got married to your spouse, there was two estates. If you get married to your spouse out of community property, there is still two estates. I hope you understand that. No in community property, no joint estate. But there are two scenarios that will apply. When you are married to somebody out of community property, you can be married to that person with the inclusion of the cruel regime and or with the exclusion of the accrual regime. So there are two possible scenarios. There are only two. It has to be one or the other. If you do not stipulate in your antenuptial contract that the accrual regime does not apply, it will automatically apply. Therefore, should you decide to get married without the accrual, you must specifically stipulate it in your antenuptial contract. But how does accrual work? So in both scenarios, with accrual and without the accrual, during the marriage, you have two separate estates. The husband can purchase what he wants to, do what he wants to. He is liable for what he does with his money. He's responsible. If he gets into financial difficulties, financial trouble, the creditor can only go to him. They cannot go to his wife, and vice versa. But if they are married out of communal property, without the accrual, the same will apply until death or divorce. So should the parties get divorced and they're married without the accrual system, out of communal property, still the same thing. The same scenario that applied to them before they got married will apply to them at termination, at death or divorce, because that's how marriage can be terminated, should be terminated. However, if the parties got married with the accrual regime, that's where it becomes a bit tricky. At death or divorce, we'll have to make a calculation. We have to now determine which estate of either party increase accrued, and whichever estate accrued will have to pay the other party half the difference. Of course, there's CPI, the Consumer Price Index, and those things. But a simple way of stipulating it is, if the husband and the wife, at the start of the marriage, they were both zero, both never had money, they maybe had a few rands, but they basically both had zero. At the divorce, the husband is now worth 10,000 Rand and the wife is now worth zero still. He will have to pay her 5,000 Rand, half the accrual, because his estate increased by 5,000 Rand. If the wife's estate is worth minus, she owes people money, that's fine. Because his estate accrued by 10,000 Rand, he will have to pay her still the 5,000, and he won't have to pay a bit more because her estate is now zero at the start. If at the start of the marriage his estate was worth 10,000 and her estate was worth 20,000, and that's declared, but his estate grew to 20,000 and her estate 20,000, because his estate grew, he will still have to pay her half the difference, meaning he still have to pay her the 5,000 Rand because his estate grew by 10,000 Rand. That's a general scenario. But had the same couple been married out of communal property, there would have been no calculations at death or divorce. I mean, she would have kept her 20,000 Rand and he would have kept his 10,000 Rand, the growth of his estate, however you want to work it out. So before you get married, you have to now consider those specific scenarios. In communal property, before the marriage, there's two separate estates, but once you get married, one estate, one bundle, one pot. Everything comes from there. At divorce, you cut that pot into half and you walk away. Out of communal property, two scenarios. First scenario, out of communal property without the accrual, as you were before you got married, the same applies during your marriage and after the dissolution of the marriage via death or divorce. But if you apply the accrual regime, everything before the marriage applies, during the marriage as well, but at death or divorce, whoever's estate grew will have to pay the other party half the difference. I hope I was of some assistance, and when making their decisions to get married, please consider what I have said. Thank you very much.